pace around a lot. That's usually what I do. That's how I study. And then it just kind of like. I study better independently. I think if you do study in a group, it should be like probably with your friends, unless your friends are really like dedicated, yeah, focused. You don't want to pick off. You want to listen. I think group study is good. Like if you all do an essay, you do an essay together, like an essay or something like that. That would be good because you look at like, oh, look, just about this, just about that, and you can kind of see that. But sometimes that's why I typically I usually study on I block myself in the cave.
I do that one. When I get into something, am I gonna just professional.
Studying is helpful. It's just like you need the people who are going to be really serious. Like, we're here to study, we're not here to go. And let's do something. That's why I choose it. So if you guys feel like that, yes. Like, I studied with my friends. I was like, I'm not getting I love you guys, but I gotta go do my own thing. These tests are coming out, I got high school. And they understood that we were going to get it. So come back to hang out after we study and stuff like that. But not everyone wants that. That's right. Next my lesson. Sorry? You're working in a medical practice. Yeah, no, that's good. It's good to try all those things. Mistakes, you know what I mean? So it's good to get a wide breadth. Like I was a container firm, and then I've now been practice. So as you do yourself. Oh yeah, I think it's the best decision I've made. All the things that I've learned, give me the opportunity to go into these fields like you definitely develop skills that you're going to take into practice.
Fabulous round, guys. Fabulous.
Oh,
Such
then,
a
yeah.
so good.
That makes you, yeah, you're going to be so prepared. You're going to be so
Or dating.
They read all the cases for both issues, is what I think. And I read so you know what I mean? So I'm just like, Oh, so. No, it doesn't.
It's just an interview.
Yeah.
It's actually because of
You think the difference in walk away?
I mean, I had to look down at the beginning of it.
No,
I was back
what is this golden
Oh. So,
Good afternoon. Please be seated. All right. The Ninth Circuit Court of Appeals is back in session. Here we are. All of us here, and I'll let each justice speak, we just want to thank you. It was just a pleasure to watch such, fine advocacy. I mean, it was just a pleasure. So you both did wonderful, and I'll let both justices also say a little something.
Oh, I get to start? Okay, well, hello. I agree absolutely with Justice Silver. You guys were both just terrific, and I would be thrilled to have both of you in my courtroom. It was a very high caliber, and I hope that you can, personally, selfishly, that you continue with appellate work, because it's like the best kind of work to do. And thank you, Jeremy. Okay, but we thought what we would do is give you a little bit of feedback, because that's the value of this. This is, after all, supposed to be a learning kind of a thing. And so you're both great. And then after we get feedback, we're going to announce then who we have to pick somebody. So I'll start then with Alexis. I thought you were great. I thought you had a very good opening. You both did this with a great opening. I like openings that say, okay, who you are, who you represent, and I'm going to show 1 and 2, and sometimes even 3. But at least if you never get a question, if you never get to even turn to your argument, which my experience, usually you don't, at least you've told us what you intend to do and where you're going to go. So that was excellent for both of you. I think that you, if I had to give you a pointer, I would say when you answered questions, you were great with eye contact to the person. Like when I asked you questions, you gave me eye contact. But don't forget there's 2 other people, even though you're going on with the answer, to turn to them as well, to kind of include them into the thing. So I noticed that you would do that, just sticking with whoever asked you the question, but try to give them a little bit more contact. You have good voice, nice demeanor, you know the cases, certainly know the record, good answer, industry standards. For both of you, I think as a practical matter, as a justice, I always find I'm looking at practical things. I'm always thinking, when we decide this case, we're going to write an opinion, and it's going to be precedent, probably for many, many years. And how will this affect future cases? And so I think it's a valuable thing to bear in mind. That's why I was asking, I think I asked you the question about, okay, if we decide this, and you're talking about 24-hour reality shows, or we have, what kind of expectation are we setting for future cases? So we're always looking at that kind of line drawing. So the more you can do to help us draw in that line, and for you, of course, the line should be drawn in a way that favors your client, whichever side you're on. But you have to bear that in mind, that that's what we're thinking. And so that's valuable. That's why the emphasis on practical. What's the practicalities of this thing beyond the law? And I liked your conclusion as well. No need to say the Ninth Circuit all the time. We know we're the Ninth Circuit, so you don't have to say the, see? You don't have to say the Court of Appeals for the Ninth Circuit said this. We know that was us. You should say, you all decided, this court decided, which kind of puts us back on, hey, don't change now, because you've decided this already. That's the point. And I think that Saul, you did that. A couple times you actually said this court and such. So turning to, and I thought your rebuttal was good, although I would say with the rebuttal, I had the feeling that maybe you were ready to say, and everything you said was exactly what you needed to say for your case, but it really wasn't responsive to what Saul had argued, or what questions that we were asking. So I know that's tough. Rebuttal is always tricky. But my advice is just listen to what are we really interested in. We were really kind of going after her on this. Well, what if she's saying it's absolutely accurate, it's accurate, it's accurate. It is accurate, but does it imply something? So I thought you could have picked up on that and really pounded it. Yes, it implies the wrong, in context, it really gave a very false, defamatory impression. So that might be something to emphasize. And LaSalle, I thought, again, you did an excellent job. Same thing with the opening. Good answer on the Robin Hood, which I borrowed. Thank you, Jeremy. Gave me that last night. I thought, oh, that's a great thing to ask. And you did that very well. It answered it. You didn't even miss a beat. Stuck to your guns on material change. Good answer on malice. Answered well. it's okay to pause, and you did. Both of you are very natural, and neither of you seemed, that you're rushing it or anything, which is great. And I thought it was, I don't know about the closing. The closing thing, I was thinking, maybe I'll ask you guys what you think with, she says to protect the First Amendment, and I thought, well, that's dicey, because sometimes some people think, oh, that's great, of course I want to protect the First Amendment, but others might think that, oh, you're trying to play on my love of the First Amendment or something, rather than following the law kind of a thing, so that you're essentially saying, if I don't go your way, that means I'm not protecting the First Amendment. I don't know however I feel about those kinds of things. That's more jury kind of a thing, more than court type of a conclusion from my standpoint. Wasn't going to sway me to vote against you, just that little thing. So really, we're being very nitpicky here, but excellent job, both of you.
And we'll hear from Justice McKenna.
That was a great summary. Thank you so much. Let me just repeat and join everything that Justice Timmer said. Both of you were excellent, and I would love to have both of you argue in our court someday. I can see you both as appellate lawyers. You have great style, tone, eye contact, passion for your cases, and I thought you did an excellent job. Just a few additional comments. In my view, I thought that the first issue on false light was much stronger for the plaintiff, and I thought that the defense had a better argument on actual malice. And so that I thought that it was really good that you started talking about actual malice. I thought, candidly, you spent too much time on the false light, and you should have been talking a little bit more about actual malice, because that's just the way I saw the merits of the case, and I think that you need to attack your weaknesses. So I thought that you turning to actual malice was a really good idea. I candidly, that's just the way I saw it in terms of genuine issue of material fact, clearly on false light. Actual malice, clear and convincing. How are we going to go? For your future moot court experiences, know which court you're supposed to be arguing in front of. So it was very respectful that both of you called us justices, but we're not justices. We're judges on the Ninth Circuit Court of Appeals, right? So when you're going to different moot court competitions, know which court you're supposed to be arguing to. And as Justice Timmer said, this is a Ninth Circuit, so it's good to say, this court decided, your court, this court has already decided this, so you don't refer to the Ninth Circuit Court of Appeals, because that's this court, okay? I really liked your passion and the way you really believed in your case. I liked your style also. You were very calm. And I really liked how you conceded that there was no case on point on industry standards. Make sure you concede issues. Do not make things up in these oral arguments. Concede what you need to concede. So in any event, overall, I just thought both of you were excellent. As an aside, I want to mention, this case was apparently filed under your fact pattern in the district court, U.S. District Court, because based on diversity, not on a federal question. So when you go into practice, we are all state Supreme Court justices. So think about which court you really want to be in. If this had not been a diversity case, the issue is basically a state law issue. And so you could have filed this, you could file this in state court. And wherever you are, think about which court you want to be in. You have to know who the judges are, which court you want to be in, and think about which court you want to be deciding the issues. Now, obviously, the constitutional malice issue is a federal defense, but I don't think, based on my understanding of the law, this case would not be removable to federal court because this was a state law case, and the claim has to raise a federal question, not a defense. So I don't think you can remove based on a defense. But so the California Supreme Court might have decided this, and then the U.S. Supreme Court would decide whether or not they're going to grant cert based on constitutional malice, assuming that the defendant lost at the California Supreme Court. So think about the court that you want to be in, and don't forget the state courts. That's the point I wanted to make. Thank you.
Well, thank you, guys. I echo the comments of my colleagues here. We discussed what they've just said. We discussed it in back there. I'm only going to add to what they said and just, again, emphasize that it was wonderful to watch. You guys are both excellent, excellent appellate lawyers. You're better than some of the ones that actually walk in our courts, okay? You were that prepared. You were that concise. You really advocated really beautifully for your clients, and I really commend you for that. So to add on to what they're saying, yeah, we did talk about, we noticed that you mentioned this court or the Ninth Circuit, but that is something that you definitely need to say, because we're all egotistical judges, so we want to hear that it's our court. We love that. Oh, this court said this. We love that. That's exactly what we want to hear. And even better, if you said, I wrote the opinion in Solano, perfect. How exactly spot on I was in Solano. We love that, especially for the dissenters over there. We're like, see, I told you we were right. Look at their, they're citing to me right now. No, that's good. You want to do that. You're going to pander, I should say, to those justices, absolutely. So I can't tell you how important it is when you don't say this court. I mean, you really miss an opportunity to just get your point through. And I also liked you respectfully disagreed with me on something and then distinguished, I know what it was, and to follow up on your point on, you were very forthright about there not being a case in the industry, but you turned it around and you looked at the record and you said, you know what, there's 4 people, producers and editors, that went through this. They know the industry, they know reality, and so you made it a positive, which is perfect to do. And I want to commend you too, because I know there were many times I wrote down good direction to the record. Love that. You did that several times. That is so important to the Supreme Court, and here's why. Yes, we read the briefs, obviously, we read our briefs, the actual briefs that are filed, and then we read the bench memo, and then we have what's called excerpts to the record that our law clerk thinks is important to the issues on appeal, right? So your 2 issues here, we would have gotten excerpts from that. But the fact that you actually directed us, I am telling you, at least with our court, if we're sitting up there, especially if it's not my case, it's maybe it would be her case. Her chambers has prepared the bench memo. I don't know the record like her chambers and her law clerks. So when you sit there and say, you said something about Solano, page 38, and another time you cited page 42 and 40, I'm going to tell you right now, I'm up on the Nevada Supreme Court, I'm writing page 40, and then the first thing I do after conference, I go right into my law clerk, I say, pull page 40, pull page 42, I want you to pull page 38. I literally will pull everything that those attorneys have now directed me in the record, because they felt it was so important in their 15 minutes for me to look at. What if the law clerk missed it? What if so I can't tell you how important that was that you did that. And that is really good to do. Let's see. What else did I have written? Sorry. Again, on your, I don't know if it was your rebuttal. I think it was your opening. You said, look, it was a different person. The family and friends didn't even know it was the same person. That's how out of context it was. Thought that was really strong. And also, you raising your hands, and there were many times that you did something, you would like raise your hands. I thought that was good in your argument. And you, I would say, it didn't matter what case we brought up, you could, cite the case and distinguish it, because we all thought that you had the harder argument for sure. Because summary judgment's a tough standard, right? So we felt that you had the harder argument, but you knew those cases, turned it around. I think I asked you something about Kaylin, and you turned it around. So I think that's all the notes I have. Let me see if I have anything else. I agree, though, with my colleagues. We just thought you did an outstanding job. Both of you were great. So, did you guys have anything else?
No.
No. Should you tell them who?
Okay, so with that, we have picked the winner of the competition. Again, this was so hard for us to do. It was so hard because you were both so good. But we believe that Wessel had won. As first. Super strong runner up there.
Yeah.
Alex. It, super strong, very hard to decide. Very hard.
And let's hear it for the bailiff.
With that, I think court is adjourned. We have concluded our intramural competition, so congratulations, Wasal. Justices, would you be willing to take pictures with us?
Oh, of course.
Thank you so much.
Of course.
And thank you again for taking the time to come and judge.
Of course.
Thank you so much, everyone.